once we've got the presentation completed, I'll send a link out to the presentation itself, and I am attempting to record our presentation this morning. So if that is successful, I'll also be sending out a link to the recording. Recordings aren't always successful, though, so it's a good thing you're on here this morning. So with that, we're going to go ahead and get things rolling. Darrel, are you ready?
I am ready.
Great. We've got Darrel Davis with us from our Division of Opportunity, Diversity, and Inclusion, and he is going to be presenting for you this morning on Title VII Basics for Local Public Agencies. It's all yours, Darrel. Take it away.
All right. Good morning, everyone. I'm glad you had the opportunity to join us. We have about 45 minutes worth of material that we'll get through. Your participation, of course, is greatly appreciated. So send those questions in. Let us get those answers for you. If there's something that I can't answer right away, leave a contact information, email or telephone number, and I'll have you an answer, hopefully by the end of the day. Now, as we go through this presentation, it's important to note that this is how we do business at ODOT, okay? Your particular agency may have a different procedure, but I'm sure they're going to follow what the law says. So we're going to review what the law says today, okay? So I might say something that sounds a little quirky or whatever to you because you might not be used to that, but just keep in mind through the presentation that whatever your agency's policy and procedures are, that's what you should follow, okay? And if there's ever a question about that, involve your legal team or someone running your equal opportunity program at the earliest point possible to clear up any confusion, okay? So what we're going to talk about briefly today, I lost my, there it is. We're going to talk about these items briefly today, just kind of a high level view of some things. I'll give some specific examples of some things, and we will talk about some case setting precedents as it relates to agency responsibility and even personal responsibility, okay? So again, I encourage your questions. So let me give you a little bit of background about who I am. I got into the field of civil rights while I was in the military. It's funny how it happened. I was in this presentation in basic training, and if you're familiar with the Army back in the 70s, they had this thing called HREO, Human Rights and Equal Opportunity. But the way it was presented during the training was that everybody who is white is wrong and they have afflicted this great pain. Well, I thought that couldn't be right. So my interest grew out of that. And as I went on to some of my more permanent assignments, I got interested in civil rights. I learned a great deal about it. I eventually became trained in it. And now here I am today here at ODOT. I came here in 2013, and now I'm the training program manager. I do have an investigations background, so I can answer whatever questions you have pertaining to case law and that. The legal authorities, our programs here are based on the Civil Rights Act of 1964. We also follow very closely the Ohio Administrative Code and the Ohio Revised Code, and we pay attention to particular things that have been outlined in the governor's executive order. But again, as mentioned earlier, you should follow your specific organization's policy and procedures. Let's talk about harassment, okay? Harassment, as defined by the Equal Opportunity Commission, is a form of employment discrimination violating Title VII of the Civil Rights Act of 1964, and we'll get into more specifically what that looks like. The Age Discrimination in Employment Act, or ADEA, and the Americans with Disabilities Act. During the presentation today, we're not going to talk about the ADA because that's a very large publication. There are so many what ifs going on with that. Perhaps in the future, we can have a presentation to the locals that talks about reasonable accommodations and accessibility and those types of things, but we're not going to do that today. So, harassment occurs in a variety of circumstances. The harasser can be a victim supervisor, a supervisor from another area, an employee, a non-employee. We've had some examples of that here at ODOT where contractors have harassed some of our employees, and it can be a coworker. Most likely it's going to be a coworker, okay? The victim doesn't have to be the person harassed to be offended by the conduct. We call that third-party harassment. Somebody looks at individuals engaged in what they believe to be offensive behavior, holding hands, rubbing, petting, kissing, and those two might not have an issue with it, but the person who is watching that or witnessing that could be offended by that, and they, of course, can come forward and file a complaint, and you should look into that, okay? Unlawful harassment may occur without any economic injury to the person or any adverse effect on that person. And we'll get into some case law that will talk about that. So when we talk about proving cases of harassment, we're looking at the conduct. Is it unwelcome? Is it based on membership in a protected category? We'll see those 10 or 11 of them here in a second. Is it severe or pervasive? And then when we talk about a hostile working environment, does it interfere to the point that an employee's job performance is suffering, or does it create an offensive or abusive and hostile work environment? So here are our protected categories. As you can see, when we talk about federal, we're saying that's the EEOC. These are things that they protect under their statutes. And then you have the code, and you have the both codes from Ohio. You have the governor's executive order, and then just to show you what we cover, we also have some things that we cover here at ODOT, okay? So these are the different categories of harassment. So when we talk about, or we are witnessing, or someone is reporting conduct that affects one or more of these categories, then we have to look at that and see what type of harassment it is, and is there something we need to pursue that. Let's talk first about sexual harassment. There are a couple of cases that establish some things. Fargo versus the city of Boca Raton came forth and said, you know, it is possible that the agency, even though they might not be aware of the conduct by the employee, is going to be responsible for that because that supervisor is an agent of the agency. Does that make sense to you? So, and then Burlington versus Industries established an affirmative defense, which means that the employee or the employer did all they could once they became aware of the behavior to correct it. And then the second part of that is the offended employee did nothing to take advantage of those things, okay? Also, click on there. When we talk about responsibility, here in the state of Ohio, there is a case, and we'll see that in a second, to where individual supervisors can also be held personally liable for offensive behavior, okay? So we got to keep that in mind as well. So just a quick review of what sexual harassment is. Any unwelcome sexual advances, requests for sexual favors, and any conduct of a sexual nature, whether it's physical, verbal, or nonverbal. When we say nonverbal, we're talking about ogling or just staring at a person in a manner that is, pardon the expression, creepy, that looks like there is a sexual intent there, okay? Then when we talk about hostile working environment, sexual harassment, does the conduct interfere unreasonably, and that's a big word there, with an individual's work performance? Does it create an intimidating or a hostile working environment? Is it to the point to where an employee says, man, I just don't want to go to work today. I'm physically sick because I have to be harassed all day, every day, and it's just one of those things that I can't deal with, okay? So two types of harassment, right? Quid pro quo, and then hostile work environment. Quid pro quo. Think about a lot of the things that are happening now, okay? The Me Too movement, where years of abuse, folks are coming forward and they are making that known, okay? Within a state structure or like ours, there is some time frames for that we protect an individual. It doesn't mean that they don't have a reason to move forward. It just says that if it happened outside of these time frames, and usually if it's with the EEOC, that's 300 days, then you'll have to take that through the court systems or even start with the EEOC. Here at ODOT, we give 180 days, okay? Something that would apply to you at the local level would be the Ohio Civil Rights Commission. They too give 180 days to report inappropriate conduct from the last occurrence of that inappropriate conduct, okay? 180 days. Those are very important. We have time frames that we strictly adhere to, okay? There is a program that I've been following on Showtime called #That's Harassment. I don't know if any of you are familiar with that or have had the opportunity to see that. But if you don't have Showtime, which a lot of us don't, I just had it because it was a trial period, you can go to YouTube and search for #That's Harassment. Now, what this is doing is they are attempting to bring to light the different forms of sexual harassment that is happening in the workplace, okay? Things that we might not think about as being harassment. One example would be one employee trying to demonstrate to the other employee how a customer might use their hands or get in their personal space and different things like that. And we might look at that initially and dismiss that as, oh, he's just trying to be helpful or whatever, when in actuality, it is harassment. So if you have an opportunity to view that, again, if you have Showtime, look for it, or you can go to YouTube and look for it, search for it under #That's Harassment. It's very educational. They're very short clips, anywhere from 3 to 5 minutes, so they won't take up a lot of your time, but that would help give some insight into the different types of sexual harassment that are going on in the workplace even today, okay? So the other one, here's our case study that we're talking about that pins liability to the agency, okay? So the agency is going to be responsible for conduct if it knew or should have known about the alleged behavior, okay? Supervisors are going to be causing the agency to have responsibility based on the Supreme Court case, which is this one, that says supervisors are agents of the agency, and therefore vicarious liability is extended to the agency, whether or not the agency knew anything about it, okay? So we have to be careful there. The other one is Burlington Industries versus Ellers, a case out of, I believe it was North Carolina, to where an individual was subjected to sexual harassment. They were promoted, didn't show any signs of an adverse action or any type of negative consequences from the employer themselves. The court said it doesn't matter. It's not necessary for them to show harm. If they are subjected to sexual harassment, they can proceed against that agency, okay? Obviously, when we talk about individuals moving forward, we have to keep at the forefront of our mind the affirmative defense, okay? And that's something, of course, that you would have to involve your legal team in if you run into some of that. Remember, affirmative defense is once the agency became aware of the conduct, they took immediate corrective action, okay? And the second part of that is the employee, the one subjected to the harassment, did nothing to minimize the harm or to get themselves out of danger, okay? Now that's walking a serious tightrope. So you have to be careful there. That's why we say, and when you come across these things and you're doing these investigations, make sure you involve your legal team, okay? They went to these very polished schools, so they get a whole lot of money to sort through things like that, okay? All right. Gennaro versus Central Transportation, the Ohio Supreme Court ruled that, hey, supervisors can be held personally liable in conjunction with the employer for discriminatory behavior. What does that mean? That means that now this individual can be sued by themselves in a court of law, okay? So that's what this decision means. So we have to be careful. So we have to make sure that our work environment is free from harassment, okay? What does that mean? Individuals who come to work have a right to work in an environment free of harassment. So we can't, as supervisors, if you're in that role, have our head in the sand about these things. Generally, if you sense something is not happening or something is happening in an environment that seems to be inappropriate, your instincts are probably correct and you need to look into that, okay? All right, so complaint process. This is very, very, very important. If you become aware of questionable conduct, right, even though there is no complaint, you should inform your higher level supervisor, okay? Communicate with your human resources department or labor relations or your legal team if you have to, or make sure you are following your policies and procedures. You'll hear me say that throughout the presentation, okay? We always want to keep in mind that the work environment has to be free from harassment so individuals can perform that function that we brought them on board to do, okay? It's very, very, very important. All right, so how do we handle complaints? Well, one, we want to take every complaint that arises seriously, okay? Take it seriously. Don't dismiss it. Oh, you'll be okay. It's an adult world. Don't worry about it. It'll get better. No. When they report something to you, you have an obligation to move that through the system to make sure that those complaints are addressed, okay? Follow your organization's complaint procedures. Interview the alleged harasser. Initiate an investigation when it is appropriate. Involve your legal department. Can't stress that enough, okay? And then forward to the appropriate person as deemed necessary, okay? How are we doing? Victoria, any questions on the line?
Not yet. You're doing great. Thank you.
That's good stuff. That's good stuff. Okay. Retaliation. A lot of the cases that we see involves an element of retaliation. How does that come about? Well, usually a person has participated in what we call a protected activity. They either filed a charge or a complaint, or they participated in an investigation, or they were answering questions during an employee investigation, they resisted sexual advances, or it could be that they were denied a reasonable accommodation for a religious or a medical condition. Either one of those things, okay? So we call those protected activities, okay? So we have to be aware of that we don't then, because we don't like what's going on, we don't like the employee bringing that kind of attention to our sections, so we're gonna punish them. We're gonna give them something that takes them out of the area, or we're gonna give them a job that they don't like, or we're gonna pester them to the point that they say, I don't want to come to work anymore, and quit, okay? All of that is retaliation, okay? All of it is retaliation. It's one of the easier forms of harassment to prove, okay? So you have to keep that in mind, one of the easiest forms of harassment to prove. Every year, at the end of the fiscal year, usually the numbers become available around the 1st of January. In keeping with my training standards that I have for ODOT employees, I like to go out to the EEOC's website to see who's filing complaints. Where are they coming from? How many of them are there? What types are they? Okay, so I pulled up the state of Ohio's complaints. The EEOC maintains this database because agencies have to report. If you have, I believe it is 50 or more employees, you're responsible for an EEO report that you submit based on the number of complaints that you have and the different types. So here in Ohio, this is what we have so far, okay, for the end of 2017. And this is down a lot, and it doesn't include all of the complaints that we got, just the major complaints. I do this because I want to see if our workforce is a reflection of what is happening in society. And for the most part, it is, okay? We have a lot of disability complaints, a lot of race-based complaints, a lot of age-based complaints, and of course, sex-based complaints, whether it be based on gender, based on harassment, or those types of things. We have those, and as you can see, retaliation, as we just talked about, is one of those numbers that happens a lot because folks do something or say something, and then before you know it, the circumstances in their job has changed. It's no longer a positive thing, it's now negative, and they are believing that that is retaliation, and they are coming forth and they are making those complaints, okay? So from time to time, especially if you're down there at the local level, you're responsible for doing investigation, go out there at the EEOC's website and see what's happening and gauge what's happening in your environment, how much it mirrors what's happening across the state of Ohio, okay? The common complaints you're gonna get: age, disability, and sex, and of course, color, okay? There has been an increase in race-based complaints and national origin-based complaints within the last 24 to 30 months, okay? Well, why is that? Well, the country just came off of a national level election. As you all know, we elected a new president and vice president, and there were some questionable things that were said during the campaign that kind of riled up each other's bases, and now this stuff is starting to spill over into the work environment, okay? So we don't want you to have this ideal that because people work in your area that they all follow the rules, okay? That they're going to be the most nice and cordial employees that you have, because remember, we don't vet individuals based on their political affiliations. Well, we shouldn't, okay? We vet them on whether or not they can do the job. So if they are harboring some ill will towards whoever or whatever for whatever purpose, that comes into the work environment, okay? So that comes into the work environment, and then it spreads amongst the employees, and then before you know it, you have a whole bunch of complaints that are coming forth and a whole lot of work to do in terms of investigations, and no one's doing their job, okay? So we have to be aware of that as well. How does individuals file complaints? From the local level, let me make this clear, you cannot file a complaint with ODOT, okay? So you would have to go to the Ohio Civil Rights Commission, there's the information there, or the Equal Employment Opportunity Commission, okay? And there's the information there. So what happens when they go to either one of these agencies is they're going to see what's called an intake coordinator, okay, who will take their complaint, write it down and put it in a charge and send it to the agency responsible, okay? As individuals go to these places, and remember, it is their right, okay, and we're supposed to give them time to do that according to how the policy is written, to let them go and file their complaint, okay? That complaint should be directed to whoever your agency head is, okay? Like in our case, Jerry Ray is our agency head. So when information comes from the Ohio Civil Rights Commission or EEOC, we expect to see Jerry Ray. Not that Jerry Ray personally did this bad conduct or whatever, but because that person works for that agency, they're no longer in the internal complaint process, they're in an external complaint process. The head of the agency is listed there. So they would take their intake, send that charge to the agency, that whoever's responsible for investigating that will provide that position statement on those charges, usually within 45 days, about what is happening. And then, of course, they will go from there, okay? Just keep in mind, as individuals go out here to these different agencies, it can take over a year for this to be resolved because there's a heavy caseload. So just be aware of that. So, in the interim, how do we make our agency a great place to work? Well, again, we're going to take all complaints seriously, okay? We need to make sure that all of our employees are aware of the anti-discrimination, anti-harassment, and anti-retaliation policies that we have copies of the policy in the work areas where employees gather. You can put it on the bulletin board or someplace central to where employees gather. We have it in their break areas. Plus, we give training to all the employees every 2 years. They're responsible for receiving this training, so we do that. Ensure the employees are aware of the internal and external complaint process, which is, of course, what we just talked about, the Ohio Civil Rights Commission and the Equal Employment Opportunity Commission, okay? Display contact information for filing those complaints internally. Who's the point of contact? Is there a local EEO person who is responsible for these types of things? Make sure that their contact information is displayed, as well as the addresses and stuff for the EEOC and OCRC. Have complaint forms readily available, okay? Or at least be able to point employees to where they can get this stuff electronically or physically, okay? And then after we've gone through this investigatory process, if we have findings of probable cause, then we want to make sure that we discipline accordingly and we do not want to retaliate, okay? That's very, very, very important. All right, so if you have questions, we will take those. Boy, this really went by fast.
We'll go ahead. I say we can open the phone lines up, and we can also, take questions in the chat pod. So I'll go ahead and unmute those that I've muted on the screen. And if you have questions, that way you can ask them.
Now, that presentation wasn't that good where we have no questions.
I thought you did a very good job, Darrell.
I get excited and I talk fast. No questions?
I've got the phone lines all unmuted now, so any questions, anyone? It said if you could please repeat where to find the videos on YouTube.
Good question. The series is called hashtag That's Harassment. Okay, all one word. THATS harassment. All one word. Very good series. Yep. Can an employee still file a retaliation complaint when the alleged complaint was dismissed as no probable cause? Yes. Yes, they can. Okay, because remember, anytime there is a complaint, the investigator is looking at that specific circumstances surrounding that complaint. And if it does not include an element of retaliation, then yes, the employee can come back later and file a retaliation complaint. Okay. Sometimes there's probable cause, sometimes there's not. Okay.
I've put Darrell's email address in the chat pod too, if you're interested in contacting him directly with questions.
And it's also on the screen.
What other questions do we have from the audience? Okay. Well, if we don't have any more questions, then we'll go ahead and wrap things up. Thank you so much, Darrell, for making the presentation this morning. And again, if the recording works, we'll send that out to everyone along with a copy of Darrell's PowerPoint.
Perfect.
Great. Everyone have a good rest of your day. Thank you.
Okay. All right. Welcome, William. All right. So they're starting to bug out. Okay.